We're outside federal court here in downtown Dallas for an update on the case that involves the rapper known as Pooh Shiesty, Lontrell Williams Jr. After about a 1 hour probable cause hearing in federal court in downtown Dallas, he has been ordered held. The judge deciding that yes, there is probable cause that he was involved in the crimes that have been alleged by the FBI. His defense attorneys argued the FBI does not have the guns they mentioned. They do not have the jewelry that they mentioned that was allegedly stolen. They do not have the contract that they say that he was forcing the other rapper known as Gucci Mane to sign to get Pooh Shiesty, the other rapper, out of his contract. But the judge said the evidence is heavy that he was involved in this, that he does have a lengthy criminal history, including gun violations before. So at this point, Lontrell Williams Jr. is being ordered held in federal custody pending his next court date. We'll have other updates throughout the day.
Well, we're going to show you the paperwork that actually says the denial. And then we're going to get into what Pooh Shiesty's lawyer said, because he decided we're going to have us a press conference. So let's get to the paperwork first, and then we'll get to the actual doggone press conference. Because he admits some things that I ain't going to hold you. It's looking like a W for Gucci. What? Of detention pending trial. Motion of the government attorney pursuant to 18 U.S.C. 3142 F1, or I ain't gonna do the other one. So we go down and we look, and we're going to see what it says. It says Part 2, findings of fact in law as presumptions under 3142E. Reputable presumption arises under 18 U.S.C. 3142E2. And that goes on to say a whole bunch of things. And then it says reputable presumption arises under 18 U.S.C. 3142E3. Goes on to say conclusions regarding applicability of any presumption established above. The defendant has not introduced sufficient evidence to rebut or presumption above, and detention is ordered on that basis, or the defendant has presented evidence sufficient to rebut the presumption. But after considering the presumption and the other factors discussed below, detention is warranted. So it says, after considering the factors set forth in 18 U.S.C. 3142 and the information presented at the detention hearing, the court concludes that the defendant must be detained pending trial because the government has proven by clear and convincing evidence that no condition or combination of conditions of release will reasonably assure the safety of any other person in the community by a preponderance of the evidence that no condition or combination of conditions of release will reasonably assure the defendant's appearance as required. And it says, in addition to any findings made on the record at the hearing, the reasons for detention include the following. Weight of the evidence against the defendant is strong, subject to lengthy period of incarceration if convicted, prior criminal history, participation in criminal activity while on probation, parole, or supervision, history of violence or use of weapons, history of alcohol or substance abuse. That's fascinating. Then it says other reasons or further explanation. Based on the credible evidence presented at the hearing, the court finds probable cause to believe that defendant committed the law violations alleged in the criminal complaint docket number 1. Thus, as alleged in the government's motion, this case is eligible for detention because it involves the use of firearms and alleges a crime of violence for which the maximum term of imprisonment is life. Again, the alleged offenses, kidnapping and conspiracy to commit kidnapping, involve the use of firearms and violent force by defendant and his co-conspirators and co-actors against the purported victim. Defendant's criminal history includes conviction of a federal offense similarly involving the use of a firearm and violent criminal behavior to which he was sentenced to and recently served a term of imprisonment. Indeed, he was still serving that term at the time of the instant offenses. At the time of the instant offenses, defendant who was released from a Bureau of Prisons, BOP facility, to home detention with location monitoring, location restrictions, and other conditions of release in lieu of a halfway house placement to complete his imprisonment term, which was to be followed by a term of supervised release imposed in his previous federal case. Per the oral report of the pretrial services officer, defendant also did not have permission to be in Dallas or the Northern District of Texas at the time of the instant offense. At the bottom, defendant violated the most restrictive of those conditions imposed by the BOP as conditions of home detention, as well as those imposed by the sentencing court of conditions of supervised release in the judgment of conviction in his previous federal case. In light of that fact, and the fact that the conditions of pretrial release at this court's disposal are the same or similar to those defendant has already violated, the court finds that there is no condition or combination of the conditions the court can impose in this case which will reasonably assure defendant's appearance as required or the safety of the community or another person if released. Accordingly, the government's motion for detention docket number 3 is granted. Defendant is ordered detained as set out below. Then it goes on to say the defendant is remanded to the custody of the Attorney General or to the Attorney General's designated representative for confinement in a corrections facility separate to the extent practicable from persons awaiting or serving sentences or being held in custody pending trial. The defendant must be afforded a reasonable opportunity for private consultation with defense counsel on order of a court of the United States or on request of an attorney for the government. The person in charge of the corrections facility must deliver the defendant to a United States Marshal for the purposes of an appearance in connection with the court proceeding, dated 4/8/2026. Hey, man, QR code, link in the description. Wednesday, that means spend day. Hit that QR code and tap that link in the description so you can start spending it there. We're going to put $5 in your account. That's free cash and Seti Nash. No better name in the game. We're like Jordan and Pippen. Peanut butter and jelly. Milk and cookies. You should be able to get yourself some now. Hit that QR code and tap that link in the description. Don't tell nobody, man. Well, you know what? You can tell somebody. Don't worry. But I'm letting y'all know. You can get paid just to play games. Hit that QR code and tap that link in the description. Free cash, Seti Nash. Let's get on with the content. All of that being included, yeah, they're going to hold him back. It was a shot in the dark if they was going to grant him bond anyways, which I believe the feds are going to do what the feds been doing and try to draft up more stuff, more shit to be said, a whole lot of things. So the same play that they did on Big 30 and the same play they did on Pooh Shiesty dad, and those two individuals are on their way to Dallas right now. But I find it fascinating that this man's lawyer came out and said this. I'm not going to interrupt or anything. It's a nice little 5-minute clip, so roll it.
So we had a bond hearing today and a PC hearing today. I think that the relevant things that were said today that I thought were fascinating were that it took 3 months to build a case. And I think the reason for that was because the statements that were given on the evening that this occurred were very questionable. I think the way that the statements were made, what was made, what allegedly was witnessed and what wasn't witnessed, I think gave great pause to the FBI. The FBI doesn't take 3 months to arrest someone if they believe everything that was said on the night that it occurred. They were involved the first night and then nothing happened for 3 months. In addition to that I thought was quite embarrassing was that an FBI agent says they don't have the resources to keep their eye on an individual. This is allegedly an individual that committed a crime that they then didn't watch to see if the guns were present, if the jewelry was present. And what didn't we hear today? What we didn't hear today is there is no contract, this mystery contract. They have no contract. They have no video of this alleged signing of a contract. They have no guns. They have no jewelry. They have none of that physical evidence. What they have is they have allegedly 5 individuals, one of them being a very well-known individual that is allegedly cooperating with the government and making these allegations against my client and many more. I'm going to take like 1 or 2 questions and then we're going to scoop.
You're essentially arguing they've got only a he said kind of case, no evidence.
Correct. Yeah, it's very fair. I think that this is it's a he said type of a case. I mean, obviously, there's 5 individuals on one side. What we're missing are the other people that were present in the room, right? The owner of the studio who says he didn't hear anything or see anything. The way they leave the studio, where no one is in concert with anybody else, no one's arguing with anyone else. One of the individuals says, "Hey, can I get my watches back?" Like, the story is quite unusual. And I think that the FBI knew that. I think the investigators knew that it was unusual. And I think that's why it took so long to make the arrest.
What is your response to the judge saying that, your client still violated the terms of this ankle monitor location?
Sure, those are all things that are going to be, flushed out. The fact is that he was allowed to be in certain areas at certain times. That really wasn't an argument for today. I wasn't really even going to make that argument. My main thrust of today was to really push on the evidence and see exactly what they had and when they had. How about this? How about the individual who wrote the complaint, who actually drafted the complaint, who was sitting in the courtroom, who's only been an FBI agent for 4 years, does not take the stand. They put someone else on to say what she wrote in her own complaint when she's sitting in the courtroom. And that's done quite often in gamesmanship because they don't want to put a rookie on the stand and be measured by our legal team.
How far away is this from trial?
Oh, who knows? You know, we're going to get discovery. We'll take a look at their discovery. They're going to say it's ongoing. I mean, think about it. They had 3 months to get this stuff. They had 3 months to get warrants. They didn't get warrants that night. They didn't get warrants the next night. They didn't get warrants the next month. They didn't get warrants the month after. They waited 3 months to get warrants on whether or not there's guns, whether or not there's jewelry. How about their cell phones? How about the computers? That gives me great pause when I see a case that takes that long to get warrants, if you believe everything that was said on the evening that it occurred.
Does
Sir, can you tell me
Let me take one from her because she was great last minute.
Can you say anything about the identity of RD, and then you also spoke about a social media post you made?
Correct. So, listen, I don't like it, when the government puts initials in and everyone takes a guess who they are. We all know who they are, right? I'm not going to say it's this person or that person. That's not my job to do. But certainly there have been media posts of individuals that we suspect were involved in that evening where they're denying that it occurred, or they're denying that they're giving statements to the government. I think that's unusual as well, because of what the government put forward today seems to negate those statements, but we'll have to see how this all shakes out. Listen, guys, Sam and I have had many, many cases together, right? We just finished a case a couple of years ago in San Francisco on the Cash App murder case. And whenever I talk to individuals, whenever I talk to the media, I always say, this is not a straight road. It's always a very winding road. So we never know where things are going to take us. We got to look at the evidence as it comes in, and we'll see what's there. I'm just shocked that, you know, when they say there might be video out there, they don't have it. There might be this mystery contract, they don't have it. Oh, they were at Staples, you know, making copies. It's just a total guess. So, like, we're not here to guess. I'm here to look at the evidence, to weigh the evidence, and to make the best decision based on that evidence.
Your client just stays in detention until what?
Yeah, currently he'll stay in detention. We get discovery. We'll start going through that. There's going to be several motions that we're going to file, obviously, in the next couple of weeks, but that'll all come out. We'll get copies.
So did the feds even interview any of the people? Did the feds even interview any of the people yet? Any of the alleged victims? Or?
So my understanding is the FBI has, over the past 3 or 4 months, has interviewed none of the alleged victims, and allegedly they all have future dates to give statements, but I have no idea if that's true. We're basing it on what the agent said on the stand, that each one of those witnesses from that evening is going to appear and give a statement to the federal authorities.
So RD never made a statement as of now?
Not to the FBI, but that evening it appears from the material that they produced and from the agent's testimony is that RD gave a statement that evening, but since that evening has not given another statement. But the FBI said in the future they're all scheduled to give statements, so we'll have to see. All right. Thank you guys. I appreciate it. All right. Thanks. Nice seeing you.
Yeah, good to see you.
Now, in a previous video, which I'll probably just posted like right here, you see that it says that somebody peered in and seen that Gucci Mane actually was getting robbed and all this crap, which to me is like, why don't you start busting? Why don't you start popping? You are security. You have the ability to do that. You're all alleged. Big 30 didn't have no guns, so you could have basically defended your client right there. And how did you know all of this stuff was going on? Now, one would argue Gucci Mane told him. True indeed. But this one right here, this statement right here, basically says that if they talk to an investigator, that right there is where it says this person spoke to an investigator. Now, one could say Lil Buddy held it down and the investigators came and talked to him way later. So that's what that is. And I would go, oh, all right, cool. No issue, no problem, no harm, no foul. But here's where the W for Gucci comes out. The lawyer just said there is no video. There is no contract. Which means Pooh Shiesty still signed to Gucci Mane. Pooh Shiesty is still signed to Gucci as it stands today. So now, that's my elbow. That's that, elbow tendonitis. When y'all been, drywalling and stuff. All my construction workers know exactly what the hell I'm talking about. But that means, bro, there is no dog on anything. Y'all ain't had no jewelry. Y'all ain't had no contract. Y'all ain't had no video. Y'all ain't had no guns. Y'all ain't had nothing. All y'all have is a violation, allegedly, that he wasn't supposed to be there. So if this goes to trial, the feds are just going to say, you know what, just violate him for violating his probation. And then Pooh Shiesty will be out later afterwards. That's it. And I keep saying this shit. Y'all, some of y'all don't understand the Sixth Amendment. The Sixth Amendment says you had a right to a speedy trial, meaning the feds, aka the government, can't hold you forever. I didn't know you. The fact that y'all would argue that is insane to me, but all right, because Bradford Cohen admits in that same thing, it's an ongoing active investigation, which means, bruh, let's hurry this shit up. So that's the part where I'm looking at it like, man, bruh, all you other cats who are in the comments, y'all speaking from emotion and not logic. This is an active investigation going on right now. And as it stands right now, it's too early to call Gucci Mane a snitch. It just is. Some of y'all will hate that I said that. And I understand that part. But one thing I can't do, I can't put it on him. I can't put it as a jacket just yet. If I ain't seen no statements, if I ain't seen shit. Whatever that shit says, whatever the damn affidavit says, RD said this, well, who did he say it to? And when did he say it? Who did he say it to and when did he say it? Because it doesn't say he told investigators. It just say he identified. Now, it's 100% possible that Gucci Mane is a snitch. All I'm saying is just like when y'all try to get me to call other people rats and snitches and shit. What's the dude who used to be from the O and he moved to Arizona? He's a Christian. Y'all sat up there and gave me all type of information on, hey, this boy's a snitch. This boy's a snitch. Put the jacket on him. He never even showed up to court. He never was a person who gave a statement. Another person was. So forgive me for saying it's too early to be calling cats snitches until we see written statements and all that shit. Now, trust me, if Gucci Mane is a snitch, I'm going to rip him from head to toe. But right now, can't do it. But y'all, let me know your thoughts. Listen, these two things are given away. We already selected 2 winners in the last video, but these 2, we're going to be giving these away at 300K. It's going to be the last giveaway. Make sure you are subscribed. That means you like every video, comment on every video, and share every video. If you want to help spread this real quick, hype it up, like it up. You diggery. But other than that, click right here to see how there's a Rico that could happen on Lil TJ. You ain't even know it. Or click right here for the playlist, and I'll catch you on the next one.